Hello and good evening to everyone joining this Facebook Live session tonight. My name is Chris Ben. I am an immigration lawyer with a firm called Seraphus, and we run these sessions in conjunction with the EU delegation to the UK on a monthly basis to try to provide information and help answer questions about EU citizens' rights in the UK post-Brexit. So for anyone who's joined the sessions before, welcome back. Thanks for joining again. For anyone who is new to the session this evening, it's a pretty straightforward format that we use. We run for usually about an hour until 6:30. And the idea is that we will cover some of the sort of questions that we get asked. We tend to sort of look at what we are receiving questions and queries about and try to choose a topic to give a bit of more information, try to shed some light. If there's policy changes that people need to be aware of, then we'll talk about those. And then we have the second half of the session for Q&A. So just answering any questions that people would like to post in the chat section. My colleague Caroline is here helping with all the tech stuff behind the scenes, and she'll pick up the questions for me. We do our best to answer everything as well as we can. It's difficult. We're not in a format where we can provide one-to-one advice. So the information that we give will be more of a general nature, but we will do our best to give as helpful answer as we can. If we can answer the question, sometimes we do get stumped ourselves, but that's the kind of broad way that the session will work this evening. And so, as I say, it runs for an hour. We do them on a monthly basis. So if there are things that you would like to be covered in a future session, please do communicate that with us. Use the EU delegation social media channels to contact us. There are specific addresses that you can write to if you have questions that you would like a written response to. Because, as I say, our purpose is to try to help people understand the situation, which can be quite complicated. And to make sure that everyone's aware of the rights that they have if they're living in the UK after Brexit. So what we've done this evening, the last couple of sessions, the June and July, we were talking about pre-settled status and how people can qualify for settled status, because the Home Office made quite an important policy announcement about how they changed the rules slightly for pre-settled status holders moving to settled status in a helpful way, which we covered at the last two sessions. If people have questions about that, then please feel free to post them. I think that it's still a topic that people want to understand more about because it's quite a recent change. But what we've done for this evening's session is to try to bring together some aspects of information about traveling and the rights to what rights people have to travel, who needs what documents to travel, how to avoid travel issues. And the reason why we want to cover this topic is because obviously since the UK left the EU, the rights to travel to the UK are dealt with. Like European citizens are now they're not entering the UK under free movement rules. They're coming to the UK under the UK's immigration system, and therefore there are different rules that apply to people depending on what category they fall into. And so it's important to understand which categories people might fall into, and once you know which category you're in, know about how to make travel as smooth as possible, because there are because it's such a big change. Brexit was such a huge legal change for the UK to be moving outside of free movement rules, that there are some consequences that can be quite confusing and can cause issues with international travel and sometimes at the UK border. So we've brought together some of these different sort of groups that people might fall into to cover in one session this evening, to give people an idea. It's sort of designed as an overview. It's not doesn't have loads and loads of detail, because obviously each category has its own detail. But that's the idea of talking about this evening. We know that people have been traveling for the summer holidays, and so hopefully that travel has been has worked and it's been smooth. But we know that there's some changes that could be coming at the end of this year, and we have a situation where there's a very new scheme in that's in place since April for EU visitors to the UK, but which has at the moment that it isn't fully enforced, but will be fully enforced in all likelihood some point in 2026. So we want to think about the future as well as reflect on perhaps the experiences that people have had traveling over the summer. So moving straight into this is the sort of one of the biggest changes that's happened for European citizens visiting the UK. So this is for citizens who don't live here. They're not residents. They're not part of the EU settlement scheme, but people who are ultimately citizens who want to visit the UK for tourist purposes, visiting purpose, business visits, family visits, all those kind of things. The UK has now the agreement between the UK and the EU for the rules post Brexit was that the EU nationals and UK nationals to the EU would be visa free. So there's no requirement to apply for a visa in advance of travel. However, there is the requirement for EU citizens visiting the UK to obtain something called an Electronic Travel Authorisation. Now, this is called ETA. Anyone who follows the delegation's social media channels will have seen lots of information about trying to kind of publicise the introduction of ETA, because it's such an important change in how people visiting the UK travel here. And what it is essentially it's not a visa as such. It's a kind of authorization. So it's a very light touch application. It doesn't ask for loads of information when you apply for an ETA, but it is something that should be done before travel. And as I said in the introduction, in 2026 at some point, it's something that will need to be done before travel, because if it's not done before the person tries to travel to the UK, then the airline or the ferry company or Eurostar will simply refuse to bring the person to the UK. They will say, you do not have the authorization. It is now enforced in full, and therefore we cannot board you, because ultimately the companies that bring passengers to the UK are subject to Home Office fines if they bring people who don't have the right permissions. So it's a really important change. So just some quick information. It costs £16. It's valid for 2 years, or the length of the person's passport if the passport is valid for a shorter period. Like, so let's say if your EU passport is expiring in a year's time, your ETA will be given for 1 year rather than the 2-year validity, because the ETA is attached to the document that you're traveling with. So it just attaches to the length of the passport if it's valid for less than 2 years. Otherwise, standard ETA is granted for 2 years. It can be used for multiple visits. You do not have to get an ETA every time you travel, but obviously there are rules about visiting the UK. So that the main one that people need to bear in mind is that visits to the UK can't go over 6 months. They have to be 6 months or less. That's the main rule. So even if you've got an ETA for 2 years, that doesn't mean you can come and visit the UK for 2 years, because your visits are limited to 6 months maximum at a time. So that's the first thing. It also applies to adults and children. So don't think that it's just for those who are over 18. It is if you've got a family traveling, everyone needs an ETA. Everyone will apply separately for an ETA. The application process can be done in one of two ways. You can either use the app that you can download to a smartphone, which will take your picture. It will scan the chip in your passport, assuming your passport has a chip, and then you will fill in some information online. If you can't use the app, then there's an online application form that you can use. The information given is the same. It's just that the difference with using the app is that it is a bit more straightforward, because it can scan the information in your passport, which saves you filling it out in the online form. There is one of the things that has been fed back to like lawyers like myself, and to the EU delegation, and to embassies who in the UK, is that some people are curious as to, like, it's a £16 for an ETA, but there are some companies who charge a lot of money to make an application on people's behalf, and that it's important to be aware that if you want to apply yourself, for your ETA, and it is a simple application. It shouldn't need an agent to make an application for you. If you want to make an application yourself, go through the gov.uk, Google Electronic Travel Authorisation UK. You will get the gov.uk website. Go through the gov.uk, you will see the apply button. That is the only official way to apply for an ETA without using some kind of third party. Third parties will offer services, but they will charge you to do that. It is a simple application, and you don't need to have a third party to apply on your behalf. And any third party who claims that they can get a quicker decision or anything like that is not correct, because all they're doing is giving your information via the gov.uk application service as well. So just something to be aware of, because it is something we've fed back on. People are quite upset about having been charged a lot of money for something which is actually relatively simple to apply for yourself. Okay, so that's just kind of an overview of electronic travel authorization. Just to be clear, when you apply for electronic travel authorization, the majority, and when I say the majority, I mean the absolute vast majority. There have been millions of applications for EU citizens since the ETA went live for them in April April this year, and there's been a minority of like a tiny percentage have been refused compared to the numbers that have been granted. So it is very like I say, the vast majority of people are granted an ETA, but just to be aware of two possible outcomes if you don't get granted an ETA, and it's important to understand the distinction between these two other outcomes. One is that the application is rejected, and the other outcome is that the application is refused. So it's actually more likely to get rejected than to get refused. And what happens is, in a rejected application is where something goes wrong with your application, not because you're not entitled to, or you don't meet the conditions to get an ETA. It's just that something went wrong in the application. An example is if the digital photo that's uploaded doesn't comply with the relevant standards, that can lead to a rejection of the application. So it's not refused, it's just rejected, because it's almost like an administrative rejection. So that's actually more likely to happen if you don't get granted an ETA. But you can be refused an ETA, and most of the refusal grounds for an ETA relate to essentially what we'd call conduct issues. So things like criminal offending, criminal convictions, previous breaches of immigration laws in the UK can lead to it. So it's all about, like, essentially negative conduct. So if the Home Office refuses the ETA because of a conduct issue, they tell you what it is that's led to the refusal, and there's nothing you can do about it. You cannot appeal against that refusal. There's no right to challenge it. What you are supposed to do if you're refused an ETA, if you still want to visit the UK, is to apply for a visit visa. And the reason that you're asked to apply for a visit visa is because these are more in detailed applications, and that goes to a decision maker at the Home Office who can look at the background of your application and decide whether or not the conduct that led to your ETA refusal, whether that should also lead to a refusal of a visit visa. To be honest, in most cases, if someone's refused an ETA for conduct reasons, that is likely to lead to an outcome where they will not get a visit visa. But it may be the case that a visit visa can be granted even though the ETA is refused. Probably if you're in that boat, then you'll be looking to speak to a lawyer like myself, or someone who works in immigration law, because you need to understand what the chances are of being granted a visit visa. But we give that information because it's important to understand that can happen, but really it's only a very, very small fraction of ETA applications that actually receive a refusal decision. The vast majority are granted. So that is ETA, and that is for visiting the UK. But then we need to move on to look at EU citizens and family members who actually are living in the UK post-Brexit, because the important thing about being resident in the UK, and particularly resident under the EU settlement scheme, is that you are exempt from the need to get an ETA. It doesn't apply to you. And this is really important because I think this is, again, something we've answered quite a lot of questions following the introduction of ETA. Is people are a bit confused about whether they need to get one, because obviously there's been a lot of Home Office and government promotion about the need to get an ETA. And even though that promotion does talk about pre-sale status, and settled status holders, it's not as prominent as just the general message, which is get an ETA if you're traveling to the UK. But so the message that we want people to understand is you do not need an ETA if you have pre-settled or settled status under the EU settlement scheme. It's not necessary. Your permission to travel to the UK. So what the airline, what the ferry company, what the Eurostar check that is that you have a permission to travel to the UK. So for visitors, that permission to travel is the ETA. But for people with status under the settlement scheme, that permission is their pre-settled or their settled status. That gives you permission to travel to the UK. It's part of your rights under the withdrawal agreement that you don't need a visa to come to the UK. You have your status under the settlement scheme. So that's what the airline will be checking when you board and when you check in for your flight, is whether or not you have pre-settled or settled status, or you might have another type of immigration status. So, like for those citizens who didn't live in the UK before Brexit took effect, and that when we talk about Brexit taking effect, we're talking about the 31st of December 2020. So, if you came to the UK as a student or on a work permit, in 2021, 22, 23, 24, 25, then you've come under the UK's immigration system, and that also is your permission to travel to the UK. So equally, you wouldn't need an ETA to travel to the UK because you have a work permit or you have a student visa, and that's what the airline will be checking with the Home Office. So, but we obviously, most of the work that we do is about people with status under the settlement scheme. So that's why I'm kind of focusing on that. But the important thing to remember is that even if you have pre-settled or settled status, that will only be seen by the airline. I'll talk about airline. I mean carrier, any ferry company, Eurostar. It will only be seen by them when they check you in if your status and the document, the travel document, which by that we mean passport or national ID card, for people with pre-settled or settled status, it will only be seen by the carrier if that travel document is linked to your UK visa and immigration account. So when you are granted pre-settled or settled status, you get a login and you can see your status online via the gov.uk portal, and that is your account. That's your UKVI account. That's your permission. That's how you see your status, and that's how you share your immigration status with other people. And within that UKVI account, you can upload your travel document, and you can upload more than one travel document, so that when you're traveling, the carrier, when they check you in on your passport or your national ID card, that document is linked to your account. The carrier then gets a message from the Home Office saying, yes, this is someone, essentially, it doesn't say they have pre-settled or settled status, it just says this person is okay to travel to the UK, because the Home Office sees your pre-settled status, but they don't need to tell the carrier what your status is, they just need to tell the carrier that you have permission. And so it's done by linking your travel document to your UKVI account, and then all of those parts come together and the carrier gets the correct message from the Home Office to allow you to travel. So the important point that all this is about, making sure that you update your UK visa and immigration account, sometimes called your digital status, sometimes called your e-visa. All of those terms are used. Again, go online, gov.uk, anything to do with your immigration status, anything official, information or services, anything official from the UK government is gov.uk. That is the website. You always need to see that in the web address to know that it's the official one. But you can type in update my UKVI account into a search engine. It will bring you to the right page, and you can follow the instructions, and you can usually update your identity document without having to send it to the Home Office. Usually you can photograph it, and it will be able to update automatically. It will be updated without you sending it, and it shouldn't take too long to do. So just something important for when you're traveling, because that's what causes the biggest amount of issues. is when people haven't linked their travel document to their UKVI account, because firstly, it causes a problem with the carrier. And once you've got past that problem, which hopefully you have, and you haven't missed your flight or anything like that, you then get to the UK border, and sometimes it means that the border force officer needs to go and check your status against what they call the kind of back end system. So not the immigration desk. They have a more detailed IT system away from the immigration desk where they can check more information. But that's the things that cause problems and delays and stress at the border. So that's why we always focus on that and make sure people update their documents. I just want to include a little bit of information about when you're traveling outside with either pre-settled or settled status. And one of the reasons I want to cover this is because of a question that came to me from an organization who supports EU citizens related to someone with settled status who misunderstood the requirements for settled status and consequently has lost their settled status. And that's really, really devastating for them, because they won't be able to get it back. They're outside of the scope of the settlement scheme because of how long they were outside the UK. So just to be clear, how it works is when you have pre-settled status, you are someone with less than 5 years of UK residence. That's why you were granted pre-settled status, not settled status in the majority of cases, and therefore you have to build up 5 years of residence to qualify for settled status. And whilst you have your pre-settled status, you have conditions on how long you can spend outside the UK. And that's what we were talking about at the last two sessions, was about how the Home Office has slightly changed the rules to make it a bit more simplistic. But it's just important to be aware that whilst you're in that 5 years of qualifying for settled status, you do have more restrictions on the amount of time you can spend outside the UK. Like I say, we'll come back if people have questions about how long that is, what the conditions are. We'll do another session on it. But broadly speaking, the rule now is from the Home Office is when you have been granted pre-settled status and you're in your 5 year qualifying, you can have up to basically half your time outside the UK, so up to 2.5 years outside the UK. But you do need, when you apply to go to settled status, you have to show that you have 30 months or 2.5 years of residence within the last 5 years. So it's not like you don't have like loads of conditions, but you do have more conditions than when you have settled status. So that's something to be aware of if you're spending, like, if you're just having holidays and family visits outside, you'll be fine because you'll never be anywhere near to being outside for more than 2.5 years. But if you do a lot of travel for business, or if you want to spend time away from the UK for other reasons, maybe some study overseas or just a longer break, then you do need to think about your 5 years of qualifying for settled status and how much time you're having outside. If you have settled status, then you have an allowance of up to 5 years outside the UK before you lose your settled status. So that is a long time you can have, and that means a continuous period. So when you are outside with settled status, even if you make a short trip back to the UK, have a weekend back in the UK, that will reset the 5 year clock. So when I say 5 years outside the UK, I am talking about continuous years where you do not step foot on UK soil. So it's a really, really big allowance of time that you have when you have settled status to be outside the UK, and it means you don't have to live in the UK anymore, because you can live overseas, and as long as you visit the UK at least once every 5 years, then you will keep your settled status for your lifetime. So it's a very generous allowance. It was written into the withdrawal agreement particularly to allow people that flexibility. So that's good. But one thing that people, and this is where the example that I gave, where it caused the problem, is that sometimes people think that it's 5 years from the date you were granted settled status. And that may be the case, but only if you're granted settled status when you're in the UK, or on the day you leave the UK, because when the 5 years is calculated from when you leave the UK. So you can basically, because you can apply for settled status outside the UK, then you could be granted. So you could leave the UK for a year and you could then apply for settled status. If you've got the qualifying residence you need to be granted settled status, you could be outside of the UK for a year, be granted settled status. But what's important to remember is that you then have to calculate that 5 years from when you left, not from when you're granted settled status. So it's not that you get 5 years from the grant, because that would give you 6 years outside, because you'd have already had a year and then you'd have 5 more years from the date of the settled status grant. But it doesn't work like that. It works from the date you left, and it's irrespective. It doesn't matter when you were granted settled status. So you have to work out time. And as I say, this is what the person that I was asked about misunderstood, because they had left in 2015. They were granted settled status in 2020, and they thought it gave them an extra 5 years. So this person in this example had been outside for 10 years, and they totally misunderstood the rules. And even though they were granted settled status, that settled status has now automatically been lost. It no longer applies, because they went over the 5 years allowance, because they misunderstood the rules. And it's something that just maybe people understand it very well, and hopefully they do, but we do sometimes see that issue arising. So just want to make sure people are clear about absences, because it's definitely one of the most of the things that I've discussed over the settlement scheme over the years that I've been dealing with it. Absences is probably one of the topics I talk about the most, because it can be confusing for people, and we understand that. Okay. So national ID cards, right? Why have we included this? Well, because the use of an EU, I'm talking about an EU national ID card. The use of ID cards is something that essentially it's a requirement of free movement law, is to allow people to travel around the EU on a national ID card. The UK doesn't have a national ID card, as I'm sure many people will be aware, and the UK, quite frankly, doesn't really like national ID cards. They think they're, as in the UK government, they think they're less secure than passports, for example, and so they don't particularly like the use of ID cards as identity documents and travel documents, and so since the UK has left the EU, the UK government has stopped allowing EU citizens to use ID cards to travel to the UK. That was a policy change that they introduced quite quickly after Brexit, to reflect their kind of view on that they want people to travel on passports. So essentially, there's only one group of EU citizens who can continue to travel on the national ID card, and that is those who are protected by the withdrawal agreement. And mainly that means people with pre-settled or settled status, although there are some other categories of people protected by the withdrawal agreement who could still use their ID cards to travel to the UK. But mainly we talk about EU settlement scheme status holders. So you can continue to use your national ID card, and that is, as you're right, it's a lifetime right that is written into the withdrawal agreement, because effectively the withdrawal agreement is sort of trying to continue how the free movement approach which was that you can use your national ID card to travel to and enter the UK. So that's the good news, is that you can continue traveling on your ID card. If you have an ID card you want to travel on, link it to your account. I just talked about that, about how important it is to have the right travel documents linked to your Home Office, your UKVI account. So make sure you do that. And if you get a new national ID card, link that to your account to make sure that you don't have problems. But one of the what has been written into the withdrawal agreement is that after 2025, so from the beginning of 2026 onwards, the UK can insist that national ID cards being used to travel to the UK are essentially biometric. So they have a chip in them that is compatible with travel standards. So this is something that will that is written into the that is written into the withdrawal agreement, is that you have the right to use a national ID card, but the UK can insist from 2026 that it is a biometric ID card, not so other ones that don't have chips in them. Now, we're giving this information because it means that people might want to start thinking, if they don't have a biometric national ID card, that they might want to think about how they applying for one before next year. Important thing to understand is that is the Home Office and the UK government hasn't actually made a decision yet about whether or not they're going to enforce this, enforce the use of a biometric national ID cards. So, as I say, at the moment, you can travel on a national ID card that is biometric, and that's fine, and that will definitely be fine after the end of this year. But if you travel on a national ID card that isn't biometric, it's fine. Definitely fine until the end of the year, but we don't know at the moment what the position will be after the end of 2025. This is obviously a question that has been asked to the Home Office, but currently they do not have a policy. Nothing on gov.uk talks about the position from 2026. So again, it's something that we will look to update people on. The EU delegation's social media channels will put the right information out once it is known. It's a shame that it's not known now, but hopefully fairly soon it will be understood so that we can get people. And obviously, if you realise then, if the policy from the UK is to enforce the requirement for biometric national ID cards, then people can make the relevant applications and do that. But that's just something to be aware of, because it could be a change that comes in from the beginning of 2026, but we don't know yet, and we will communicate about it once we do know. Okay, the last sort of topic heading that we wanted to cover off in the travel section this evening is to do with certificates of application. Now, anyone who has applied to the settlement scheme will be familiar with a certificate of application, because you would have been issued one when you applied. It's the first thing that should happen when you submit a valid application, is you get a PDF email, or an email with a PDF attachment, and it says certificate of application. And what that is that's your confirmation you've applied to the settlement scheme, and it lasts, it's valid for as long as the application is being processed for. So if you then get granted pre-settled or settled status, then the certificate of application is no longer needed because you've been granted status, and that's great. And the majority of people who applied to the scheme, the millions of people who applied to the scheme, have been given status. Like we're up to, I think it's about 5.7 million individual people have been given status. So that is great, and they have so their pre-settled or settled status is what they need. So certificates of application don't matter anymore to that group. But there are some people who haven't yet got a decision on their application, and what we're talking about is people who have not got any status under the scheme at the moment. So if you have pre-settled and you're applying for settled status, you don't get another certificate of application. You don't need one because you've already got pre-settled status. But if you are applying and you hadn't got any status and you'd make your application to the settlement scheme and you're waiting for a decision, you will have a certificate of application, and you will need to use that when you're showing that you have rights whilst you're waiting for the Home Office to decide your application. So it's not actually known how many people still need to use the certificate of application, but it's likely to be in the tens of thousands. So quite a lot of people, but it's the figures are not exactly they're not. You can't figure them out from the published data on the settlement scheme. But it will cover people who might be appealing against a Home Office refusal decision. If the Home Office refused to grant status, then people can appeal. Previously, you could make something called an administrative review if the Home Office refused your application, and those take quite a long time to be decided. Appeals also take a long time to be decided, waiting for court hearings and so on. So there are a lot of people out there who are probably still trying to use a certificate of application because they haven't got status yet. And hopefully in time, the application will be resolved and they will get status. But it's really important to understand what the rights people have when they have a certificate of application, and particularly to do with travel, because travel is definitely the most contentious area to do with traveling. With using a certificate of application, because the reason is because there's different legal opinions about what rights people have. The UK government has a view on certificates of application and what travel rights people have. The EU Commission has a different view on what travel rights people have with the certificate of application, and the Independent Monitoring Authority. If you're familiar with this organization, they were set up by the withdrawal agreement to protect citizens' rights. They have another view, which is a sort of a combination of views of the UK and the EU Commission. And so there is no agreement exactly on what a certificate of application does allow people. So it makes traveling a very complicated area. And quite honestly, when we get people who approach us to ask about traveling on a certificate of application, our initial question is likely to be, do you need to travel? Is it necessary to travel? Because we know the problems that people can face trying to return to the UK. And actually, the best way to avoid problems is to avoid travel, I'm afraid. If people do not need to travel, then it is quite likely that the best approach is to not travel, because it can be challenging to use a certificate of application to travel back to the UK. And there's two reasons for that. One is because if you can travel to the UK's border, when you get there, the UK border force, they have to assess whether your certificate of application should permit you entry to the UK. And that will depend on what your situation is. Are you someone who was living here by the end of 2020, an EU citizen, and you've applied and you're waiting for a decision? And do you have evidence to show that you were living here and that you actually continue to be a resident? That means you might be able to cross the border. If you're a family member, a sponsored family member, it's a very complex situation. It can depend on whether or not you've been granted what's called an EU settlement scheme family permit in the past, even if that may have expired now. So family members are very, very complicated, and we really do encourage people, if they're in the UK, not to leave the UK if they are sponsored family members, because it really can be problematic to return. So there is a very the policy at the UK border, and the reason why we want to include this tonight is partly because it's one of the biggest headaches that we get in terms of travel questions, and also because there has been some engagement between the Independent Monitoring Authority and the Home Office about this issue recently, and the Independent Monitoring Authorities asked some questions of the Home Office to try to get more clarity on it. But even if that clarity is provided, the Home Office position seems to be to remain that you need to be able to prove at the UK border that you're entitled to re-enter, and if you can't prove that, then you can be refused entry. And there are stories, and there's media reports, there's organisations who we work with who are approached by people who are simply refused re-entry to the UK even though they've been living here, and that's a really big problem that we have. So so that's one problem, is the UK border. And if we dive to the next slide, then we'll get to the next problem, which is to do with the introduction of electronic travel authorization. Just waiting for the slides to catch up, which hopefully will happen. There we go. So because since April, ETA has been introduced for EU visitors, that has an impact. We've talked about it already. It has an impact on people with pre-settled and settled status, because when you have pre-settled or settled status, you have to be able to show you don't need an electronic travel authorization, which is done through linking your travel document to your UK VI account. But it means that, but what the issue is for certificate of application holders is that a certificate of application is not permission to travel to the UK. So if you show a certificate of application to an airline, they are not going to get confirmation from the Home Office that you have permission to travel to the UK, because you don't have an ETA, because you can't get one if you live in the UK. You do not qualify for an ETA because that's for visiting the UK, and you don't have pre-settled or settled status, which is like a full immigration status. What you have is a certificate of application, which is neither. It is neither an ETA nor is it immigration permission. It sits in sort of a bit of a grey area, and so carriers can say, well, we don't think you have permission to travel to the UK using your certificate of application. And that's obviously a real problem, because even if you got to the UK border and you could satisfy the border officer that you should be allowed to enter the UK, you may never get that far, because you can't get to the UK border because the carrier is saying, we can't bring you to the UK border. At the moment, the Home Office has a policy position where they say that they are not fully enforcing the requirement for people to have an ETA. So what that means is, a carrier, if an EU visitor gets to check in with their carrier, the airline, and they don't have an ETA, then the carrier can still bring them to the UK. They should encourage them to apply for an ETA. This is for visitors, of course, but they don't have to the person doesn't have to have an ETA at this moment in time to travel to the UK border, and the carrier won't get in trouble if they bring someone without an ETA. That will change in 2026, but because at the moment the full enforcement of ETA is not happening, what the Home Office says is, well, this means that people with certificates of application can also travel, because even though their certificate of application is not like a permission to travel for a carrier, because carriers are not fully enforcing the rules at the moment, the person with a certificate of application can still be brought to the UK by the carrier, and the carrier will not be penalised by the Home Office if they do that. Now, that's a very unsatisfactory position, because that requires the carriers to understand quite a kind of complex policy position, and they need them to understand what a certificate of application is. And really, it's not very helpful. So, because some carriers will just say, you don't have permission, we're not going to bring you to the UK, and that's the end of the discussion. And it doesn't really matter what the Home Office policy may be, because this is not stuff that's written down in a very obvious, accessible place. And so it does create a massive issue for people with certificates of application. And again, it's why we say to people who approach us about traveling on a certificate of application, is like, this is why it has become so difficult for you, because first of all, you have this border issue that I just described, and that's been something that's been an issue for several years. But now you also have the added problem of maybe the airline's not going to let you board the flight back to the UK, because they might not understand that they can do that even if you have a certificate of application. And so you've got a double possibility of facing problems when you travel. It's not, as I say, it's not very satisfactory. At the moment, there isn't really a solution, and this is part of the reason why the Independent Monitoring Authority is engaging with the Home Office, is because of the problem that ETA will cause this group of certificate of application holders. So there needs to be some clarity on what the actual approach should be, which will hopefully clarify the position, and potentially, I mean, as I said at the beginning of this particular section, there's a disagreement between the UK and the EU Commission about what the rights of someone with a certificate of application and travelling is. And so it may be the case, if someone is refused entry at the border, they may need to bring a legal challenge against that refusal to argue that the position is incorrect. And so there's all sorts of problems, and it's not something that we can really sort of give a clear resolution to in this. We just want to raise awareness of it. And as I say, I think the first question that we tend to ask people in our firm when we asked about this is, do you need to travel if you have a certificate of application? Because if you don't, then you're probably better off not traveling at all, because it can be so difficult. So that's the kind of areas that we wanted to cover in terms of travel this evening. Hopefully, it's been helpful to understand the different situations, and obviously, I'm very happy to answer any questions that have come up during all of this. And whilst I'm waiting to see if there are any questions that people have raised, we just want to always emphasize this point about, if you do need any kind of immigration help or advice, then make sure the person you speak to is a regulated advisor. They will be able to tell you how they're regulated and which organization regulates them. And it's important because any kind of immigration services, the person must be regulated. They must have the qualification and the permission to give you advice. And if you don't speak to a regulated advisor, you will not get the right advice in all likelihood, and that's problematic, of course. Okay, so we have some questions. So let me run through these in the order, and hopefully I can give some answers that will help people. Right. So someone says, I have got married and will add their spouse's name to the passport at the next passport renewal. They have settled status. What steps do they need to add settled status to the next passport that will be issued under a different name? Okay, so the way that the Home Office works with the settled status account is that they will follow the name on your passport. And what that means is that there's a part of your passport called a machine readable zone, and it's the bit down the bottom of the photograph page, which has got lots of dashes and lots of like so kind of computer language almost. And that's the part that they will take the name from. And so when for most people, basically, when you apply, they will take your name from that, and that's the name you will be given in your UKVI account. So if you update your passport and you change your name and your whole passport is changed to your new name, that will be followed when you update your UKVI account. So your new name, if it is attached to your passport, including the machine readable zone, that will be given to you in your settled status account. So it takes a bit longer because you've got a new name, so the Home Office has to verify it. But that's how they will do it. So what the Home Office says is, you need to change your national document first, and if your national document has a new name, we will follow your new name, as long as we accept you're the same person, which they should do. So that's how it will work. So once you've updated your passport, you use the update my UKVI account function, and hopefully it will all be done. You used to have to send your passport to the Home Office. Now they say that they should be able to do it without having to see it in most cases, but sometimes you still have to send it. But that's how it will work. So we have a question about the traveling on the national ID card, which is essentially, there is a lot of confusion regarding the ability to travel using a national ID card. It says EU citizens cards, but I think that means national ID card from 2026 onwards. Can I clarify what will happen after the end of December this year? So hopefully the slide that we covered, that we talked about, will give as much information as I'm in a position to give, which is there could be a change, but we don't have confirmation of that yet. So the two things that I wanted to emphasize in that slide, which was, one, if you have a biometric national ID card, you do not need to worry, because that has to be accepted from 2026. The Home Office cannot stop accepting biometric national ID cards if they are compliant with the travel standards. There is like a particular reference, but most biometric ID cards issued by EU member states will be. So if you have one of those, do not worry. Whatever happens in 2026, you are still allowed. If you have a non-biometric ID card, keep watching for our social media messages, because we will tell you once we know if the Home Office is saying no from 2026 onwards, or from another date. They could choose a date. They could say, well, actually, it'll be 2027. We'll change the rules. But we will tell you what we know once we know it. But if you do have a non-biometric national ID card, do keep following our social media accounts, because we will need to give you that information, because we do not know the policy yet. We're asking the Home Office to give the policy, but we don't have it yet. Okay. I have someone has asked about their father-in-law having served a 6-year prison sentence, but not in the UK, and whether he would be able to travel to the UK to visit. I mean, as I said at the beginning, this isn't the place to give individual advice because we don't know all the facts and it's a public forum. But the immediate answer is going to be he will have a problem because that is a very long prison sentence, even if it didn't take place in the UK. And that means ETA would likely be refused, and probably a visit visa will also be refused, because that is just a serious conduct issue, and therefore the UK wants to stop people with serious conduct issues coming to the UK. But to know, it could have happened 50 years ago, and therefore maybe there's an argument that it's not something that should prevent a visit to the UK. But so you would need to talk on a one-to-one basis to a qualified, regulated lawyer to have a better understanding of that. Okay. So we have a question. If someone with valid pre-settled status under the EUSS and a pending upgrade application to the settled status has to replace a damaged passport but cannot update the new passport details on their UKVI account whilst the application is being considered by the Home Office, could an airline outside the UK deny boarding because the API system, which is the Home Office system that talks to the airline, no longer verifies the immigration status? So the answer to that is yes. I guess yes. Unfortunately, some that situation could happen. Yeah, the carrier might say you're traveling on a new passport that hasn't been. The Home Office doesn't know about it yet because they won't let you upgrade your passport whilst your application is under consideration. And this is something that has been identified as a bit of a problem because you have pre-settled status. So in principle, you should be able to update your UKVI account. But the Home Office position at the moment, as I understand it, is that whilst an application is pending, people are not allowed to do that. So you're presenting a document to the carrier that the Home Office is unaware of because you haven't been able to update your account. So the carrier doesn't get any information from the Home Office. So there are some mitigations that are in place that the carriers are supposed to follow in that scenario. So the first one is that you can give them a share code that you can generate from your UKVI account, which obviously shows your face and your biographic details, and they can check that share code, and that is something that carriers are told that they can do, and obviously because you have pre-settled status, you will be able to get share codes. So that's the first thing they can do. The other thing that they can do is the Home Office has something called a carrier hub, which is like a call line which is open all the time, where carriers contact a UK Home Office official, Border Force official in the UK, and they can ask specific information about passengers. And this is nothing new. This is something that's been in existence for a long time. And the idea is basically it's obvious that sometimes people have problems, something doesn't work, and therefore what the airline wants to be able to do is to check with the Home Office what the position of that traveller is, so they can use that carrier call line. And of course, if you have the details of the old passport and you have your new passport, then that can be linked together to show that you have pre-settled status. And so you would be in that position. You should be able to clarify in an alternative way than the main way that the Home Office does this, which is by the kind of direct, what they call the interactive API communication, so the messaging between the Home Office and the carrier. But yeah, I wouldn't want to say that it's like, yeah, this is something you will always work out, but in principle there are other ways to check someone's status, and something which will be used. And at the end of the day, at the moment, because ETA is not being enforced, the fallback position right now is that the carrier should just let you travel, even if they can't verify. If you're a European citizen and they can't verify your situation, they still should let you travel, because that's the enforcement of ETA is not in its like, it's still in its kind of soft landing phase at the moment, if you like. Okay. Next question is it possible to change nationality online from a UKVI in the UKVI account from an EU passport to a non-EU passport whilst having pre-settled status? What a good question. So again, changes of nationality used to mean that someone had to send the passport to the Home Office to them to verify, because they say it's a change of information. It's not just, you're not just renewing your passport, but they have updated that, as I understand it, so that it can be done online now, that you can add a different nationality. The one thing that I would want to understand about this person's situation, just to be clear, I would just want to understand it is do they still hold the EU citizenship as well as a non-EU citizenship? Because if you have pre-settled status and you were here as an EU citizen before the end of 2020, you need to complete a 5-year qualifying period as an EU citizen in order to qualify for settled status. If halfway through your 5-year qualifying period you stopped being an EU citizen for some reason, and became a non-EU citizen, you would actually then not qualify for settled status. So I would kind of want to know a little bit more about the background to this. But my understanding is you are supposed to be able to add a nationality without having to send your new passport with the change of nationality to the Home Office. However, I don't know if the fact it's EU to non-EU creates an additional question mark that the Home Office would have about your situation. So I can't give the definitive answer. So I'm not done it, so I don't know what the answer is, or not done it recently, so I don't know what the answer is definitively. But yeah, the only way to know about the online system is to try it, and if it doesn't work, they tell you to send it to them. Right. I'm going to re-emphasize this because it's come up again, but hopefully this message is now clear. On the use of EU national ID cards from 2026, can I clarify whether the government can stop allowing ID cards altogether, or does it simply mean they can require biometric cards, but cannot invalidate ID cards as travel documents? So what the Home Office can do is say any EU citizen with pre-settled or settled status who wants to carry on traveling using a national ID card rather than a passport has to have a biometric ID card. That's the policy that the Home Office could introduce. And I don't know if they're going to introduce it because we don't know the information, but that's what they could say. But they can never say people with pre-settled or settled status can never use any kind of national ID card. That isn't possible, because that's the withdrawal agreement prevents that. So they have to accept biometric national ID cards in 2026, 27, 28 for lifetime. But they could say in 2026, we are going to stop allowing people to use non-biometric ID cards. That's the only policy position they can take, is that one. And we don't know if that's their policy position yet because they haven't announced it. Okay, and the final question that we have is, since most people do not have any physical proof of their settled status because the letter they send you is not proof, how do people who do not have a smartphone or any other such device prove their status when traveling back to the UK after a holiday? They cannot generate a share code on the spot, and it's not they're saying it's not a legal requirement to possess a mobile phone. I think that's sort of tongue-in-cheek, but yeah, of course not. One thing, just to be clear, like I'm not here to, certainly wouldn't be here to defend everything about the digital status system that the Home Office has in place, because there's quite obviously some serious issues that need to continue to be addressed, because it doesn't always work, and that causes problems for people. And it's not supposed to. It's supposed to help people, but it doesn't always help people. So the digital status system is by far is not perfect, and I wouldn't want to. Nothing I'm trying to do tonight is to present it as without issues. I think a lot of the issues with it are known, and there's some organizations who do a great amount of work trying to make the system better for people. And also the Independent Monitoring Authority should be making sure that digital status works for people with under the EU settlement scheme, so you can report issues to the Independent Monitoring Authority. And so there's always things that should be improved. So, but what we're trying to do in terms of these questions about what to do at the airport, or wherever you're trying to travel from, is try to make life as straightforward as possible. So the answer about share codes is you can print off a share code, or create a share code and write it down, and it's valid for 90 days. So you do not need to be able to produce a share code on the spot to give to a carrier. The share codes are valid for 90 days. So as long as you're not traveling for more than 90 days, you can produce one before you travel. If you are traveling for more than 90 days, produce one at some point within 90 days of you coming back to the UK, so it'll still be valid. So you do not need a smartphone accessible at the airport to use a share code with a carrier if they're going to check it. As I say, the way the system is supposed to work, if you have updated your UKVI account with your travel document, then, or the one you're using for travel, then there should not be a question. The carrier should be able to ask the Home Office the information they need. Your UKVI account has the correct travel document. Carrier gets the positive information they need to allow you to travel. So it shouldn't even need a share code. That's the idea. The share codes are not a useful way to deal with passengers, like 200 people on a plane producing a share code. That's not an efficient way to do anything. It's as a backup. So the idea is that the system works just based on your travel document being linked to your UKVI account. And then, as I said earlier, if the carrier has the option to contact the Home Office using the carrier call hub telephone line, and they can check your status using that way. So there's also an alternative, again, which doesn't require a smartphone. So what I'm trying to say is, hopefully there's mitigations in place. I would not want to present it as if there are not problems and people haven't been forced to miss flights and things like that, because I'm aware that they have. I don't think it's sort of, in the grand scheme of the number of people traveling, I don't think it's loads of people, but it clearly happens, and that means something that the system doesn't always work. But there are supposed to be mitigations in place, but feedback and learning is really important. So, as I say, the Independent Monitoring Authority have a complaints portal if you have an issue. Obviously, if you feel you've been denied boarding unfairly, you can try to raise a compensation claim. If your flight is covered, not every flight into the UK is covered by compensation. There's rules around that, but you can obviously try to claim compensation if you've been denied travel. So, but hopefully it works for people. But the key for you to do the right thing, as far as the Home Office and as far as the carrier is concerned, is to keep your ID documents updated on your UKVI account. That is the main way to avoid any of these issues, which is why I've said it probably quite a few times this evening about updating. So sorry, I'm not sure I'll be able to deal with this, but in terms of the question about moving from an EU to a non-EU passport, it seems that the situation is someone who wants to surrender their EU passport, which I think means give up their EU nationality. And so if that is the case, then definitely be taking legal advice about your position under the settlement scheme before you move to give up any kind of EU nationality, because it could have a very significant impact on your right to move from pre-settled to settled status. So I would be make sure you take legal advice with a regulated advisor who understands the settlement scheme, because that's really, really important before you do anything, assuming that this is not, if it's a decision to be taken in the future rather than something that has already occurred. But even if it has already occurred, you need to know your position. Okay. Thank you for all the questions. Really appreciate those, and hopefully we were able to kind of cover the kind of areas that people had wanted to understand a bit better. As I said at the beginning, we do this on a monthly basis. There'll be another session in sort of towards the end of September. We'll advertise it in advance. If you have questions for us, please feel free to use our social media channels, ask us questions, suggest topics. We want to cover what is important to people. But I'm really grateful for everyone who's joined and for the good questions that have probed some of the information, because I think it's produced a helpful conversation. Thank you very much. Have a lovely evening, and we'll see you again next month.